All members, if you could, please silence your phones. At this time, let's go through the roll call.
Senator Carroll.
Here.
Senator Deneen. Senator Neal. Senator Nemes.
Present.
Senator Reed.
Here.
Senator Stivers.
Here.
Senator Thomas.
Here.
Vice Chair Wheeler.
Here.
Chair Storm.
Here.
Thank you. For anyone who wishes to speak on a bill, I remind you there's a sign-up sheet at the podium by the door. At this time, do any members have guests they'd like to introduce? Senator Tom, or yes.
Thank you, Mr. Chair. I am pleased today to have one of my outstanding district judges here today, Judge Melissa Moore Murphy. If you could stand. It's good to see you here, and I would ask that this committee make her feel welcome this morning.
Thank you. At this time, we'll go ahead and call Senate Bill 75. That'll be first on our agenda. It's an act relating to concealed deadly weapons, sponsored by Senator Reed. Senator, if you could, again, just state your name for the record and identify any guests you may have.
All right. Thank you, Mr. Chairman. I'm Senator Aaron Reed from District 7, and with me I have Taylor McKee. Would you like to introduce yourself?
Nice to meet you, Mr. Chairman, members of the committee.
Please turn your microphone on.
There you go.
That might help. Apologies. Taylor McKee with the National Rifle Association.
Mr. Chairman and members of the committee, I bring before you today Senate Bill 75, which seeks to restore equality for all legal adults in Kentucky by lowering the concealed carry age from 21 to 18 years old. This bill is about fairness, constitutional rights, and the ability of young adults to protect themselves just like any other law-abiding citizen. At 18 years old, a Kentuckian is legally an adult. They can vote, they can sign contracts, they can marry, they can be tried as an adult in court, and most importantly, they can serve in the United States military. We trust them to carry a rifle on the battlefield to defend our freedoms, yet we deny them the right to carry a concealed weapon to defend themselves at home. This is an unjust double standard, one that must be corrected. Now, some may argue that lowering the concealed carry age will make it easier for kids to get guns. But let me be very clear, this bill does not change who can legally purchase a firearm. Federal law still applies. Background checks still apply. Nothing in this bill weakens or changes our existing gun purchasing laws. It simply ensures that those who are already legally allowed to own a firearm are given the same right to carry it responsibly, just as they would at 21. The courts are recognizing this unfair restriction. In January of this year, the Fifth Circuit Court of Appeals ruled that it's unconstitutional to deny 18 to 20-year-olds the right to purchase firearms. If we acknowledge that they have the right to own a firearm, then why are we denying them the ability to carry one for their own protection? For me, this issue is somewhat personal. I have an 18-year-old daughter, and as her father, I want her to have every legal tool available to defend herself. This bill does not force her or any 18-year-old to carry a concealed weapon. It gives them the choice. Self-defense is not a privilege, it's a fundamental right. This is not a radical idea. It is a common sense correction to Kentucky law that brings us in line with our values of individual liberty and responsibility. I urge this committee to stand for equal rights for all adults, to respect the Constitution, and to pass this bill. Thank you. I'll let Mr. McKee here. He has some words as well.
Morning, Mr. Chairman, members of this committee. Like I said previously, my name is Taylor McKee with the National Rifle Association. We support this legislation, Senate Bill 75. allowing 18, 19, and 20-year-old law-abiding young adults to carry a concealed firearm. We thank the sponsor for bringing it. Young adults 18 to 20 are among the people protected by the Second Amendment, and they should not be barred or discriminated against from carrying firearms for self-defense. Many young adults are familiar with firearms, whether it be through hunting, shooting, or training with family. They're also allowed to purchase handguns, but currently cannot carry or bear them. By the nature of being young and starting out in the workforce, young adults are more likely to get the late night shift at the hospital or on the job site. These folks are the ones who are out at the most dangerous hours of the night and deserve a right to protect themselves against these criminals. I'd also suggest that members with daughters, as previously stated, would be able to protect themselves from aggressors and be able to carry a concealed firearm. This would also make the right to self-defense more consistent with other adult rights, such as voting, entering into contracts, serving in the military, and being held both civilly and criminally liable in a court of law. The Heller and Brewer decisions uphold the right of law-abiding citizens to keep and bear arms for self-defense. The Constitution also clearly states that the rights of people shall not be infringed. 18, 19, and 20-year-olds are clearly contemplated as people in the Constitution. As I stated, they're allowed to assemble, speak freely, enter into contracts, be protected from unreasonable search and seizures, invoke their Fifth Amendment right, get married, and so on. For these reasons, young adults fit squarely within this definition of the people and for the rest of the Bill of Rights. Why shouldn't the Second Amendment also extend to them? As stated, the Supreme Court has said if a modern-day gun control law runs afoul of the Second Amendment, then it's presumptively unconstitutional and unenforceable. If the law implicates it, then the burden would shift to the government, and they would prove that there is a long-standing tradition of firearm regulation that is analogous to the modern-day gun control law. As it is now, young adults are currently being infringed upon as it pertains to their Second Amendment rights, and there is no long-standing tradition or history that would justify this. It's quite the opposite. The Bill of Rights was ratified in 1791, and a few months thereafter, in 1792, Congress passed the Militia Act. The Militia Act of 1792 was a national standard that allowed for 18-year-olds to be in the militia. These young adults were responsible for purchasing, maintaining their own privately owned firearms, black powder, and for defending the country if called upon. Not only was it expected of them, but it was required for 18, 19, and 20-year-old young adults. The act of carrying a firearm is covered by the plain text of the Second Amendment. This is covered when the Constitution states keep and bear, and they are also classified as people. For these reasons, we believe that all law-abiding young adults should be able to carry a concealed firearm for self-defense. And in closing, sir, this bill expands civil liberties. It allows young adults to protect themselves and their loved ones. This bill allows young mothers and daughters to carry and protect themselves against criminals who, I might remind you, do not follow the law regardless of what this great body passes. This bill is a step forward for the Second Amendment rights in Kentucky. The National Rifle Association is proud of the work this body has done as it pertains to the Second Amendment rights, and we hope it continues in this endeavor. Thank you very much for your time.
Thank you. I think Senator Carroll had a comment or a question, I should say.
Thank you, Mr. Chairman. And oftentimes when we review this, I get confused in what the stipulations are on the carry. My understanding is that an 18-year-old can carry open carry, right?
Yes, sir.
Okay, and also a military member can do concealed carry at 18, correct?
Yes, sir.
Okay, and I think it's important to note that. I personally do not see anything to gain by passing this bill, and that's from 24 years as a law enforcement officer. And, you're always taught to assume that everyone is carrying a concealed weapon, mainly with the segment of society that law enforcement often deals with. And I think this is just going to kick that up to another level, and they are going to be carrying concealed. And I was lost when we took training away from carrying concealed with constitutional carry. My entire adult life as a law enforcement officer, I was trained regularly to know how and when to shoot that gun. The idea of people carrying a concealed weapon who may not even know how to shoot that weapon is terrifying. And I think we went too far there, and I think this is another step where we have gone too far. Thank you, Mr. Chairman.
Senator Thomas.
Thank you. And sir, tell me your name again.
Taylor McKee.
Mr. McKee.
Yes, sir.
Mr. McKee, you cited the Fifth Circuit decision. And my staff got that decision for me last night, and Senator Reed will testify. We had a long night last night. He was with me. but I did come home, and I did look at that decision late last night. And you will agree with me that what the Fifth Circuit said was that although you can't discriminate between adults 18 to 21, it did make clear that states still have the ability to make differences regarding, how they carry it, what training they get, what the qualifications they are for purchase. And so we're not required by that Fifth Circuit decision to say that 18-year-olds can carry concealed weapons. Kentucky could still differentiate under that Fifth Circuit decision between 18 and 20-year-olds in terms of having the right to carry concealed weapons. Isn't that allowed under the Fifth Circuit decision?
And since y'all aren't in the Fifth, yeah, that would not be binding, sir.
Okay.
We did have, I think, two people signed up to speak, Kathy Hobart and Chuck Eddy. Are you in the room? If you wish to speak, please come to the table.
Thank you.
Sorry, please identify yourselves for the record, and you may proceed.
Yes, my name is Kathy Hobart, and I'm a mother of 6, a grandmother of 9. I also happen to have a PhD in developmental psychology, which means that I know a little bit about the development of the adolescent brain. I've been a volunteer with the gun violence prevention movement since 2 students were shot and killed at their high school in Marshall County. Those students were the same age as my 2 youngest children, and it was then that I realized that it could have been my family, my children, my community. I had to do something to stem this tide of death and destruction. All of you sitting here should know that it could be your family too. But unlike me, you actually have the power to do something to protect our young people, or at the very least, not make our communities more dangerous. As Senator Carroll said, the young people in the age group 18 to 20 do not have the developmental capacity to carry a gun without any training, which is what you would be allowing these young people to do. They could put a gun in their pocket, go to the park, and get in a fight and shoot somebody without it, and it'll be on your hands that this was a legal thing for them to do, not the shooting, but the carrying of the gun, without them knowing anything necessarily about how to train. We also heard Senator Reed say that it doesn't change anything about background checks. That's because we don't have background checks in the state of Kentucky. You can get a gun in the state of Kentucky without a background check very, very easily. And so anyway, it would be much more dangerous. More children and teens in Kentucky died by gunshot than by any other means. Yesterday, all of you, every single one of you, voted to protect our children as they are getting on and off their school buses. And that was a very commendable bill that you all passed. But how many kids are killed getting in and out of the bus? Today, you're deciding to allow their peers to carry loaded, concealed weapons at parties, at the park, at the mall, at the parade, at the festival, on the street. You know it is dangerous, and you know this is wrong. Young adults are 3 times more likely to commit homicide than other people whose brains are more developed. If you put more guns into more young people's hands, more of them will die and more of them will kill. Do you really want this on your conscience? Vote no.
Does Mr. Eddy have any comments?
Yes, I do.
Very briefly, sir.
I'm Chuck Eddy from Lexington, Kentucky. Thank you, Chairman and committee members, for the opportunity to testify on this bill. I oppose this bill to decrease the age for concealed carry from 21 to 18. Guns are the #1 killer of children 18 and under in this state and in the country as a whole. I believe it's only a matter of time until an 18-year-old high schooler concealed carries a gun into a school and kills. We just lost a high school student in Lexington 2 days ago, Arsenio Jackson Jr. I have a grandson in the public schools in Lexington, so it's personal. We need more sensible gun legislation like universal background checks and secure gun storage bills to reduce gun violence. I'm very concerned about this opening it up. It's not about the right to bear arms. It's conceal carry, and that's a whole different world. This bill will not reduce gun violence. Please vote no. Thank you very much.
Thank you for your comments. You can ask one question, yes.
You had indicated the opportunities that 18-year-olds have to carry guns. You mentioned they could go to parks and playgrounds and malls and parties. Under this bill right here, you could also add, and you talked about the school bus provisions that we passed, school bus bill we passed yesterday to keep our children on school buses safe. You could also add, couldn't you, that these 18-year-olds now could carry guns on those school buses. Isn't that correct?
Well, I don't really know what the laws are about carrying guns on buses. I'm under the impression that it's still illegal to have a gun on school property.
Thank you. See no further questions. Senator Reed, if you don't mind, come back to the table.
Motion on the bill.
We have a motion on the bill. We have a second. We have a first by Senator Wheeler, second by President Stivers. At this time, we'll call a roll.
Senator Carroll.
I'd like to explain my no vote, Mr. Chairman.
Limit to 3 minutes, please.
Mr. Chairman, you know, in every other issue that we deal with here in Frankfort, when we look at young people, we always look at the age of 25 as being when the brain matures, and there's science to back that up. That's realistic. And, you know, I really think that that's something we should apply to this issue also. And I very much support the Second Amendment. I own guns. I support everyone owning guns and protecting themselves. I have no issue with that. I have no issue with the Constitution. And I am a strong supporter of our Constitution. Our forefathers did not draw up that Constitution considering where this world is today. And we must take a common sense approach on these issues to protect our public. And you can use this argument either way as far as protection, but I don't think that's what they had in mind. I don't think there's any way they could envision the things that happen today. So to put a gun legally concealed in the hands of someone that age, when we know that 25 is when the brain matures, I see that as irresponsible, and I don't see this as a Second Amendment issue at all. And there comes a point when common sense and doing the right thing has to take precedent. Thank you, Mr. Chairman.
Senator Deneen.
Explain my vote.
Yes, please.
At this time, I vote pass on this bill, and I do so for this reason. As a former educator, I understand that 18-year-olds are seniors in high school, and I want to make it clear that this does not change any laws when it comes to schools outlawing weapons, guns, anything of that nature on buses or anywhere else. And I'm fully aware that our service members at 18 are trained. They're trained to carry these guns. And I would like to see in this bill some type of training involved in the carry conceal side of this at age 18. I'm fully supportive of the Second Amendment. I am not in any way saying this is not a good bill. I just, at this time, I would like to work with the bill sponsor to see if there's anything else that we can add in there to make this bill a little bit stronger going forward. So at this time, I'm going to pass, but I'll reserve the right to change that as we go to the floor.
Senator Neal. Senator Nemes.
Aye.
Senator Reed.
Aye.
Senator Stivers.
Explain my vote, Mr. Chair.
Yes, please.
I vote aye, and I know I'm limited to 3 minutes. But I want to go back and look at some things as it relates to personal history. We've talked about our forefathers, and I do respect Senator Carroll's opinion on this. He has great expertise. But teenagers fought in the Revolutionary War when our forefathers drafted the Constitution. 1941, December 7th. I know 3 young men, one 20, one 19, and one 18, enlisted in the Army because of a tragic event that happened December 7th. One of those was my dad. The other 2 are my uncles. My uncle stayed from 1941 to 1970, seeing both World War II, Korea, and Vietnam. My dad stayed 6 years and went into Dachau. In 2018, I got a call that my 19-year-old son had decided to leave 2 years of electrical engineering and enlist in the United States Marines. And that May, I put him on a bus with $20 bill, a Bible, and his driver's license. I think those instances show that we have, within the recognition of the United States government and the state government, that teenagers are able to defend our country, and therefore they should be able to purchase a weapon and carry it as any other adult, because at 18, our laws recognize them as such.
Senator Thomas.
I'd like to explain my no vote.
Yes, please.
Let me be the lawyer first. Under the Fifth Circuit decision, there's nothing constitutionally requiring us to do this. As was indicated by the gentleman representing NRA, the Fifth Circuit made clear that even though 18-year-olds should be allowed to purchase guns under the Constitution, states still had the authority to set restrictions on how they purchased it, what requirements they had to purchase it, and how they could carry it. Okay, so we're not constitutionally required to do this. Not to mention that we're in the Sixth Circuit, not the Fifth Circuit. So that's the legal analysis. More importantly, the social analysis, which is what we're doing now is putting more and more guns in the hands of young people to do bad things to anyone. And as everybody knows in this room today, we have more guns in America than we have people. And to allow more guns today to proliferate here in this state, it's just absolutely dangerous. I know in my hometown of Lexington, we have seen in the last 2 years a significant decrease in the murder rate. You know, we have cut our murder rate more than half. And as I've indicated to this body already, Lexington, of the top 100 cities, now has the second lowest murder rate per capita. And that's because we've taken definitive and intentional steps to get out and work in the community to make sure that we decrease guns and remove guns in the hands of young people and give them, more positive interactions to stop this. I cannot vote under any circumstances to just allow freely and without any caution young people, 18-year-olds, to have guns concealed to move around, to do whatever they want, whenever they want, however they want. And to the statement made today about serving your country, there is a big difference in 18-year-olds being able to serve their country and carry guns to make sure that they are defending the freedoms and liberties which we enjoy to protect our country. I'm all for that. But I'm not for, as was indicated, 18-year-olds carrying it to playgrounds, carrying this to parties, carrying this to malls, carrying this wherever they want to go, to use that gun, at a second's notice to harm someone. So I am not going to vote for more guns in the hands of young people to do more harm for this society. And so I'm going to vote no.
Senator Wheeler.
Explain my yes vote.
Please proceed.
One, I'd like to echo the comments of President Stivers, but I think it's important to point out, and with all due respect to my colleagues who disagree, we're talking about people who want to purchase a a firearm and go through the system in the right way. We're talking about kids that want to obey the law. I mean, most of the gun violence we see out of youth are children that are purchasing illegal guns off of the street, and that is a more prevalent thing in parts of our society. And therefore, good law-abiding citizens, sometimes universities and things are not located in the best part of town. I think my law partner had an incident when she was at U of L Law School that she got a firearm after that to defend herself. What we're looking for is young people who want to step up to the plate to have the right to defend themselves just like every other law-abiding citizen. And I think that I want to thank the sponsor for bringing this bill. I think it's a good bill, and it just brings parity to law-abiding young men and young women who want the same right of self-defense as every other American has by the rights guaranteed in the United States Constitution. Thank you.
Chair Storm.
Aye. Senate Bill 75 is reported favorably with the expression of opinion the same should pass. Next on our agenda is
Mr. Chairman,
yes.
Could I make one last comment?
Very briefly.
Yes, sir. So I just wanted to say, Ronald Reagan once said, evil has no power if the good are unafraid. And if we can pass this in the Senate and the House, then it'll empower our daughters and our young folks to be unafraid. Thank you, sir.
Thank you. Next on our agenda is Senate Concurrent Resolution 89, a concurrent resolution directing the establishment of the Kentucky Restoration of Voting Rights Task Force, sponsored by Senator Jimmy Higdon. Senator Higdon, if you would identify yourself when you get a second and any guests that you might have, and the floor is yours, sir.
Thank you, Mr. Chairman. And as not a member, I'm Senator Jimmy Higdon, 14th Senate District. I do have a guest, not being a member of the committee. May I introduce a constituent in the audience?
Certainly.
Okay, Teresa McMahon Miller, District Judge for Hart and LaRue County. I think she's still in the room. Welcome. Thank you, Mr. Chairman. Mr. Chairman, Senate Joint Resolution 89 is a typical resolution we do to encourage leadership to do a work group during the interim. Like I said, this is asking for a task force, but we typically don't do those. This is for a work group for restoration of voting rights, which we passed in 2020, and it'll probably be back up again next year. 5 House members and 5 Senate members, Mr. Chairman.
We have a question from President Stivers.
Senator Higdon, you and I and others have had these discussions about, and actually I think it was a bill we worked on, and you expanded a bill that I passed. Well, I don't want to say I passed. Actually, it was a former state representative that we substituted the substance of the bill in, creating the method of expungement, which in essence creates a legal fiction that you never had a conviction. And then I think the years after that, and I think the state rep has since died. Darrell Owens. It was Darrell Owens. We did a committee substitute into his bill during the administration, creating this pathway. You, I think, came back a couple years later, and we expanded the respective crimes that could be considered for expungement, and we passed that. Now, with that kind of historical perspective, the thing I'm going in to ask about this, if you would be open to amending something, and make no doubt, I do not like and have never supported anything related to the expansion of use of marijuana. But since we have legalized components of it, to looking at within this task force about on marijuana charges for those people who have been convicted, where it may now have been something that was legal now but illegal at the time, including that in a look of a task force.
Mr. President, I'd love to do that. That would be a good subject to add. Most marijuana convictions are covered in our current expungement laws of the Class D felony, but you have to apply for them. We should make it automatic since it's now a legal substance.
To me, it is a matter not of whether you like the issue or not, which I'm clear I don't. It's, to me, a matter of equities. And not only we can do a restoration of civil rights, but there are federal crimes as well that people have been convicted for that they probably wouldn't even be looked at today for the purpose of prosecution because of the status of the offense. And that's kind of my point in asking this. And if you are open to working on it, again, not for my support of the product, but a matter of equities.
Mr. President, there's some other expungement issues, misdemeanors. If you have a fake ID, it's enhanceable, and that will never come off your record. If you did, and we know a lot of college students get charged with that, and you can't ever get it off your record. So we need to look at a few of those things. Thank you for bringing that up, Mr. President, and hopefully you'll support this task force.
Take just a moment of a chairman's privilege here. Going back to what President Stiver just pointed out, I did file just yesterday a Senate concurrent resolution to establish an expungement task force. So perhaps you and I can consult and work together on those measures as this moves forward.
I think that would be a perfect task force, the two of them combined.
Thank you. Seeing no questions at this time, entertain a motion on the bill. We have a motion by Senator Carroll, second by President Stivers. Mr. Secretary, please call the roll.
Senator Carroll.
Aye.
Senator Deneen. Senator Neal. Senator Nemus.
Aye.
Senator Reed. Senator Stivers. Senator Thomas.
Mr. Chairman, I explain my aye vote in about 1 minute.
Yes, please.
Okay. Where I agree with President Stivers, I will acknowledge that as well. And I agree with President Stivers here. I think we're at the point in our society now where we understand that marijuana isn't the same kind of harmful substance as other more addictive and deadly substances as we see, such as fentanyl. And I think it is equitable and right where those persons in the past who were given huge sentences for and harmful sentences because of use of marijuana, that now we would turn the other way. We should find some way to treat them the same now, retroactively, as others today. So I think that's a good idea. I support that idea. I support this task force. I do want to add that there was a representative from my area, Representative Jesse Crenshaw, who for years, pushed what we call House Bill 70 for the automatic restoration of voting rights. And Representative Crenshaw was a champion for that. So I do want to give him some acknowledgement as well in this area. But I do vote aye.
Senator Wheeler. Chair Storm.
Senator Wheeler didn't get the registration.
Sorry, explain my vote, Mr. Chair.
Yes, please.
Out of respect for the sponsor, I'm going to vote aye to take this out of committee. But I guess I would like to reiterate that, we have done a lot of work as a General Assembly, some before I got here, some afterwards, about creating a pathway for folks to get certain things expunged off their records and reenter society. But, I am against any type of wholesale restoration. I think part of the rehabilitation process and the reentry process is to take responsibility that you can go down to the courthouse. This process is not that complicated, and God forbid, maybe you have to hire a lawyer sometime to help through it. I mean, and I just don't see what the problem is with that concept. So I'm going to vote aye, but I do believe that we're going and pushing this stuff just a bit too far, and but out of respect for the sponsor, I am a yes vote.
Chair Storm.
Vote aye. Senate Concurrent Resolution 89 is reported favorably with the expression of opinion the same should pass. Thank you.
Thank you, Mr. Chairman, members of the committee.
Next on our agenda is House Bill 38, an act relating to orders of protection, sponsored by Representative Tipton. Members, I would note as he's approaching, there is a committee sub that was passed out. That makes a small technical change. I'll discuss that in a moment. I don't think that the representative is opposed to that, nor is the AG's office opposed to that at this time, but I'll explain that in a moment. Representative, if you could, just please identify yourself for the record and your guest.
Thank you, Mr. Chairman, members of the committee. I am James Tipton, State Representative for House District 53. I have with me today one of my constituents, Ms. Mary Ann Pratt.
Thank you. Please proceed.
You know, we live in a difficult world now, and no one should have to go through life under the constant threat of harassment or concern or threat that somebody is going to be out there to cause you physical harm or maybe take your life. House Bill 38 deals with orders of protection. Currently, a violation of an order of protection is a Class A misdemeanor. No matter how many violations, no matter how many convictions that a person has of this. What House Bill 38 would do, upon that third violation, that third conviction of an order of protection, it would take the penalty up to a Class D felony. There are stipulations that it would be a felony if this third or subsequent violation involves the use or attempted use of physical force or the threat of physical harm. And it also stipulates that it would be the same victim in the third or subsequent violations. It would be for that same victim, and there is a 5-year period within which this would apply. And that's pretty much the essence of the bill. Mr. Chairman, at this time, if it'd be all right, I'd like to ask Ms. Pratt if she could share her experiences with the committee.
Yes, if she could sum those up, yes.
Okay.
Good morning. Good morning. My name's Mary Ann Pratt, and I'm a survivor of domestic violence. For a long time, I have lived in fear, feeling isolated and powerless. But today I am here as a victim, but as someone who has reclaimed my strength and my voice. Sharing my story is not easy, but I do so with the hope of bringing awareness, offering support to others in similar situations, and proving that healing and freedom are possible. No one deserves to live in fear, and no one is alone. Back in December of 2022, I was awakened by my now ex-husband beating me at 4 a.m. in the morning. He was hitting me in the abdomen, beating my face, everywhere. He knocked me to the ground and held me down by the back of my neck and told me that if I moved or tried to say anything, he would kill me. And I laid there on the floor waiting and wondering, what am I going to do? I don't want to die. So after a while of him sitting there motionless, I asked him if I could sit on the edge of the bed with him, and he said I could, told me not to say anything. I realized he had a loaded gun beside him, and he just sat there. I slipped my feet into my flip-flops that were under the bed. I grabbed my cell phone out from underneath of my pillow and slipped it into my pocket, and I thought, I have to go. I took off out of the bedroom toward the back door, and he caught me. He threw me up against the door frame. He beat me. I put my hands up, I scratched his face, I ran out the back door, I ran up the hill and down the hall down the road until I could hide behind a truck, and I called the cops. The police got there, they were able to arrest him. He was taken to jail. It was missed that he was on probation. He was released the first week of January. We had our DVO court case on the following Tuesday. On that Tuesday, he was placed on an ankle monitor. He was not to come around me, and I was to be safe. The following week, he broke his DVO over 20 times by calling me, texting me, sending me messages. And then he showed up at my house one morning at 2 a.m., beating on all the doors, trying to get in. When the police arrived, he still had his ankle monitor on. And I found out that he had sat outside of my house watching my house for over 2 hours before he tried to get in. He was rearrested, taken to jail, By the time we went to court in May in the final court case, he had 50 violations against him for domestic violence order violations, stemming from being rearrested prior to being rearrested and from being in the jail, where the jail themselves allowed him to try to call me. He sent third-party messages to me through his family, and they allowed him to send me a 3-page letter telling me how much he loved me and how much we were going to get back together and how everything would be great. He was sentenced to his probation violation, and then for the assault on me and the DVO that they lumped into one because you can't have multiple, he was given 90 days and then 90 days of home incarceration. All that was to start after his probation violation. In August, he was to start his 90 days. They made him serve 3 days, and the Shelby County Jail decided he was a good inmate, and they released him. Within 6 days, he had already broken his violation again and was rearrested. He was found in contempt, and then after all the probation, all the time in court, he was supposed to serve until March the 29th of this year. In December, the Franklin County Jail decided he was a good inmate. They released him again on December 30th. By the first week of January, he had already broken the domestic violence order again. So we have a case pending right now in family court for contempt. But while he was at home waiting on that, he ended up taking to social media, threatening to kill me, to the point that if I was reincarnated, I'd come back as an abortion. He has multiple posts against me on Facebook and another probation violation. He was arrested, put on home incarceration, and banned from all social media. This past week, he decided to say that being non-compliant and not following the rules was a good thing. He started posting again. He was rearrested last night. How many times do I have to go through this? I worry when he gets out, what's it going to be? Is it going to be just a little, I'm posting, I love you, I post, or is it going to be, I'm going to kill you? That's where it has gotten to. And I'm here for all victims. And it's not only women. There are some men that go through this with being a victim also. But when does the victim actually not have to be victimized? When do we get a say? When do I get to sleep? Because when he's out, I don't. My only sleep is when he's in. So that's why I reached out to Representative Tipton. And I was so thankful that he listened to me and that he took my words and what has happened to me and what happens to so many other victims. And that's why I'm thankful that I was allowed to come and speak with you all today. And I appreciate you all so much.
Thank you for your comments. I want to mention, members, we have a Senate committee substitute that is before you, and I just want to turn your attention to page 2. It would begin at line 3 through 5, and basically that it would state that upon a request of a petitioner, the court may excuse a petitioner from future court appearances, and it's also reiterated on page 4 at lines 13 through 15. This is something that Representative Tipton had spoken with one of our colleagues who's done extensive research on these kinds of situations, as well as the Attorney General's office. And so I worked on this sub with them, and so at this time I'd entertain a motion on that sub.
Motion.
We have a motion and a second. All in favor say aye.
Aye.
The Senate Committee substitute is adopted. And do we have any questions at this time? We have one from Senator Carroll and then Senator Thomas.
Thank you, Mr. Chairman. And ma'am, thank you for being here today, and thank you for telling your story. Unacceptable, no question about that. And my comments are not going to be in relation to your situation, so please don't take it that way at all. Representative Tipton, there's no excuse for someone to violate the order when it's issued. However, there is a reality that many times the victim will actually initiate the contact that leads to the violation of the order. And again, there is no excuse for that person violating that order. It's an order, and it doesn't matter if the victim initiates the contact, they're still held to that order. Was there any consideration with this? Do you see that being an issue and I know you can use anything as a defense in court, but were there conversations about this? It is a reality.
Appreciate the question, Senator Carroll. And again, I'm just going to reiterate the portion of the changes in law that in order for it to be a Class D felony, it would have to involve the use or attempted use of physical force or threat of physical harm. So that we took that into consideration in the House and added that language in because we are aware of those type of situations that you mentioned.
Senator Thomas.
Representative Tipton, I don't follow many House bills when they're filed until they get to the Senate. A few, but not many. But I will tell you, when I came here this session, yours was one of the ones I took a real interest in. And I'm going to support your bill because I think it's an improvement in the law. But I want to share this with you and others in this room once we pass this bill into law. Okay? I think the weakness in this bill is that it doesn't really address the kind of serial abuser that can occur, because you could have a situation where you have an abuser abuse woman A, then woman B, and then woman C. Okay, so already that's 3 abuses right there. Then he comes back and abuses woman A again. Well, that's considered under this law just one violation. Okay, then he does B and C again. So now he's had 6 offenses, but he's only had 1 violation under this law. You see where I'm going here? You know, I like the 3 strikes and you're out law, and I'm going to surprise a lot of people. I'm pretty tough on crime, okay? But I think the reality is if you've got someone who's has 3 violations total, regardless of the fact that it may be 3 or 4 different women, then he or she ought to be punished. I think that's the weakness here. That at some point, not because I'm gonna vote for your bill. I hope we pass it. But I think we've got to come back maybe next year or year after that and do a better job of getting these serial abusers, out of this, off the streets.
If I may,
yep.
Senator Thomas, I appreciate you bringing that up. The original version of House Bill 38 said on the second offense for any violation. However, in the House, when you're dealing with attorneys, who knows what's going to happen, Senator. But
let me just
let me interject. Go ahead, Senator Storm.
So we have the Attorney General's office here, and what I've committed to them to do is to work with them on a Senate floor amendment that would address this very issue. And we've already got language that is contemplated, and so that is a recognized issue, but that'll come up on the Senate floor to resolve that issue, Senator Thomas. At this time, seeing no further questions, we have a motion and second on the bill. Do we?
Motion.
We have a motion by Senator Wheeler, second by Senator Carroll. Mr. Secretary, please call the roll.
Senator Carroll.
Aye.
Senator Janine. Senator Neal. Senator Nemes.
Aye.
Senator Reed. Aye. Senator Stivers.
Explain my I vote.
Yes, please.
Just quickly, like to explain my I vote. And Representative Tipton, I barely see your guest because of the poll, but when people want to violate the law, they're going to violate the law. The statutes may have been insufficient in part of this, but the system really failed her. And since you have a representative of the Attorney General's office sitting right behind you, or at least from my direction, I think you should have a discussion with them about all the things that took place. Because if there was an assault and multiple occasions afterwards, and this gentleman did, as you said, occurred, then the system failed you more than the language failed you.
Senator Thomas. Aye. Senator Wheeler.
Aye.
Chair Storm.
Explain my yes vote just very briefly. I agree with everything Senator Stivers just pointed out. Courts have inherent contempt power. And from my experience, they can incarcerate someone for up to 179 days for each instance of contempt. I could be wrong on that, but I don't think I am. And so if there were 50 violations, that would be 179 times 50 in my calculation. So I agree that it sounds like the system failed, not the legislation that was before the system. However, I don't know what happened with the charging decisions or the lack of charging decisions, but we are going to try to address this issue in this legislation. Thank you. House Bill 38 is reported favorably as amended by the Senate Committee substitute with the expression of opinion the same should pass. Next on our agenda and last on our agenda is House Bill 201, an act relating to theft by failure to make a required disposition of property, sponsored by Representative Lockett. Representative, would you please have identify yourself and any guests, please?
Yes, thank you, Mr. Chairman. My name is Matt Lockett, State Representative out of the 39th District. My guest is Mr. Ian Goff, and also have on Zoom Mr. Joe Ross, who is the President of the County Attorneys Association.
Please proceed. You have the floor.
Thank you, sir. I will be brief because of time, but House Bill 201 is simply a bill that was brought last session to the House. It was House Bill 95. We worked through it in the House, passed it, got here to the Senate. There were some issues that the county attorneys had with the bill. So we worked through those, got agreement from them, from the rental association as well. Everybody agrees on it. So we are here to bring it to you and get it passed this year.
Seeing no questions, I'd entertain a motion on the bill.
Motion.
Do we have a second?
Second.
Second. We have a motion from Senator Wheeler, second from Senator Reed. Mr. Secretary, please call the roll.
Senator Carroll. Aye. Senator Deneen. Aye. Senator Neal. Senator Nemus. Senator Reed.
Aye.
Senator Stivers. Senator Thomas.
Mr. Chairman, let me briefly explain my aye vote.
Please.
I remember this bill last year, and there was a lot of unreadiness by some of my constituency in connection with the fact that there may be instances in which landlords might abuse this provision. I may want to revisit that, but on the face of it, there's nothing wrong with this bill at this present time, so I'm going to vote aye. When it gets to the Senate floor, I may or may not have a different viewpoint, but I'm going to vote aye today.
Senator Wheeler.
Aye.
Chair Storm.
Aye. House Bill 201. House Bill 201 is reported favorably with the expression of opinion that same should pass. Thank you.
Thank you, Mr. Chairman.
Seeing no other matters on the agenda for today, I'd entertain a motion to adjourn.
Motion.
We're adjourned.